Friend, another Saturday and another episode of Legal Words of Wisdom, Nyay Gyan Ganga on our Virat Hindustan Sangam social media channels. We are back today with Dr. Subramanian Swamy and with Dr. Venkat Iyer. And today's episode will be another interesting episode. And today we'll be discussing some landmark cases and what they tell us. During the last 73 years after independence, India has seen many landmark cases emerge from its judiciary, especially from the Supreme Court, which has touched the lives of millions of Indians. How important are these cases? What can we learn from them? And can the court make mistakes? When that happens, is it possible to carry out course correction? These are some of the issues that we will be discussing in today's episode. As you all know, we have the legal words of wisdom, Nyay Gyan Ganga, every Saturday at 8 p.m. And on every Sunday at 8 p.m., we have our regular show. So tomorrow we'll be again meeting for our regular show at 8 p.m. But today we'll be discussing the legal work. And for that we have, as you know, Dr. Venkat Iyer, who is a barrister, mediator, and legal academic person based in UK. He was was originally at the Indian Bar in Mumbai, and then he went on towards United Kingdoms and has been associated with numerous organizations and giving lectures and talks to various people, organizations, including the judiciary around the globe. So with this, we welcome Dr. Venkat Iyer and Dr. Subramanian Swamy for our Saturday weekly episode. We also thank our viewers, which are spread all over the globe, for their various responses and especially the viewership on our various social media channels. Some of them watch us live, some have watching us after the episodes are over as per their convenience. We thank them, and we thank them also for their feedbacks which we get from time to time. So with this, I would now request Dr. Swamy to initiate today's discussion or today's talk with his initial remark, and then it will be over to Dr. Venkat Iyer. I thank our team, my co-host Ramesh Swamy, for his constant support, and also I thank our technical team led by Ashish Shetty,
Tejas from Pune, Ishwar Iyer from Navi Mumbai, Vishal Mehta from Mumbai. Then we have Swaminathan from Chennai, and we have Rakesh Gadgi from Bangalore. So I thank them for their support for this weekly program, Legal Words of Wisdom. Over to Dr. Swamy.
Thank you very much, Jagdish. This is a very important subject that we have taken up today. And couldn't think of a better person for me than Venkat, who has been not only a lawyer but a scholar, and has a long, tradition in legal field, as well as his concentration on the technicalities as well as the broader issues. If people in India keep asking me questions, which broadly I will divide as in two parts. And the judgments, relevant judgments, landmark judgments, I'm sure Venkat Iyer will be able to identify. One is, I have rights, statutory rights, constitutional rights, and fundamental rights. These are all subject to restrictions, what they are called as reasonable restrictions, and they are stated in the Constitution itself. At the same time, the executive and the government, there is the government, which is the executive, parliament, and even the judiciary, they have themselves limits to their power. What they can do and what they can't do, what they can lay down, what they can't lay down. So therefore, it's very important for a citizen to know that what are not only my rights or the power of the government, what is the limitation on those powers, including on my rights. And so there are a series of judgments. Can I, just because I have majority in parliament, can I, or even 2/3 majority, can I amend the constitution, say that I am now prime minister for life, like Xi Jinping has just now done, and Putin has done in his parliament, that he will be prime minister, he will be president of Russia till 2036. So one on life, and that also passed by the Parliament of China. What is they go by another name, and the Russians have done it. Can it be done in Indian Constitution? Can you, by 2/3 majority, say that the president of India will be known as the king, and the powers of the prime minister will be transferred to the president, who will be known as the king or the queen of India? So this limitation of power of these three pillars, plus of course now the fourth de facto pillar called the press, and the citizens' rights and the limitations on that, there are a series of judgments, and if we dealt with all of them, of course, it will take us probably months and months of daily hearings. But I'm sure that Venkat will be able to select those important ones so that you can build on that by doing your own research in the future. So over to Venkat, and it's all yours. Please inform us what is our reach, and what is the reach of the government, and where is the limitation.
Thank you, Swamy. I must admit it took me a while to decide on how to structure this week's talk. The aim, of course, is to give you an idea of some of the landmark cases that have driven the development of India's constitutional law, and particularly of the citizens' rights. But so large is this field that covering it comprehensively in the course of one or even two lectures would be well nigh impossible. So what I've decided to do is to undertake what I may call a whistle-stop tour of the case law landscape as it has developed over the past 70 odd years, and to note some of the major cases while spending a little more time in discussing 5 or 6 particularly momentous cases. It would be foolish or rash for anyone to be able to claim to compile a definitive list of the, let's say, 10 or 20 or even 100 important cases. So I'll steer clear of that temptation. There are certain cases which I will not be touching upon. For example, the temple cases, because those cases can be best explained by Swamy, who has been personally involved with them. Now, it's quite possible that the cases I'm going to talk about may not be considered important enough by some of you, and it's equally possible that others may complain about my not bringing up some other case or cases that they consider important. For all this, what I can do is offer my apologies in advance. I also want to apologize to those more informed viewers who may find my treatment of cases cursory or superficial. I have to be conscious of the fact that this program is aimed at lay people and not a specialist audience. And for that reason, I'll have to simplify what I say. In my last lecture, I pointed out that within weeks of the Constitution coming into force in 1950, the government led by Jawaharlal Nehru began amending it on the grounds that social and economic reform was being impeded by the provisions on fundamental rights. The complaint was that the government was being prevented from giving effect to the directive principles because the fundamental rights were standing in its way. I explained that that argument was flawed because the constitution makers had taken all factors into account, including the need for social and economic reform, and had, after extensive deliberation, organized the constitution in such a way that it would be impossible for any responsible government not to achieve the objectives listed in the directive principles without sacrificing fundamental rights. The fundamental rights were intended to be brakes on reckless or irresponsible action on the part of governments which did not care what means they adopted to achieve those ends. This is what happened in a few cases which were decided immediately after the coming into force of the Constitution. There were 2 cases dealing with freedom of expression, Romesh Thapar and State of Madras, and Brij Bhushan and Delhi. Now, you'll have to forgive me for my style of describing the case names because I'm more used to the English style in which and is used for verses, but both are equally acceptable. In these 2 cases, the Supreme Court struck down restrictions that had been imposed on 2 journals, one from the left and the other from the right, one in Madras and the other in Delhi. Crossroads and Organizer, those were the names, respectively. The government orders in both cases sought to impose the restrictions on grounds that the publications in question were a threat to public safety. But public safety was not a ground on which restrictions could be imposed under the Constitution. It was not enough, said the court, to rely on security of the state, which was mentioned in the Constitution, but which was an entirely different concept. You can see how strict the courts are when it comes to protecting fundamental rights. Meanwhile, in another case, Champakam Dorairajan and Madras, a law which laid down strict quotas based on religion and caste for admission to medical and engineering colleges was struck down, again on the grounds that the Constitution did not authorize such discrimination. Now, in fairness to the government, it has to be said that the law in question, which was contained in a government order, had been a legacy from British rule. But that was neither here nor there as far as the court was concerned. It ruled that any such discrimination, in this case against Brahmins, could not be justified simply on the grounds of social justice reform. because it violated Articles 29 and 15 of the Constitution. Again, the court was taking a strict view in favor of fundamental rights. A third case, which irritated the government, related to land reforms and specifically the abolition of zamindaris. One of the zamindars in Bihar had gone to the Patna High Court and argued that the government's actions in taking over his estates were unconstitutional, and the court agreed. This was the case of Kameshwar Singh and Bihar. Against this background, Nehru introduced the First Amendment to the Constitution, which, as I said in my lecture last week, curbed freedom of speech, allowed for caste-based reservations in education, curtailed the right to property, and worst of all, sought to insulate certain laws from judicial scrutiny through the creation of the Ninth Schedule. This was the starting point of the erosion of the Constitution. It was also the first building block in what subsequently became a huge edifice to keep the courts away from protecting the Constitution, contrary to the settled wishes of those who wrote that document. But the courts continued to soldier on. Shortly after the First Amendment was enacted, the Supreme Court gave 3 judgments which angered Nehru further. 2 of those cases were from West Bengal, Bela Banerjee and Subodh Gopal Bose, and the third was from Bombay, the Sholapur spinning and viewing mills case, all of which involved the right to property in one form or another. The government retaliated with the Fourth Amendment to the Constitution in 1954, which not only introduced further curbs on the right to property and allowed for government monopoly in trade and business, but also added more laws to the Ninth Schedule. Now, one of the things worth noting, incidentally, is that although the Ninth Schedule was originally intended to shield land reform laws from judicial review, as the years went by, all kinds of laws which had nothing to do with land reform were added. As good an example, if you like, of mission creep, as you can imagine. And around this time, the poison of proclaiming the directive principles to be superior to the fundamental rights had begun to be introduced into the bloodstream of Indian politics, with Nehru himself leading that process. The next important development came in the form of the 17th Amendment enacted in 1964. This was a response to the Supreme Court's judgment in a case from Kerala called Kunikoman, in which the court struck down a law which, in simple terms, sought to seize agricultural land without payment of fair compensation and in a discriminatory manner. While this amendment was being debated, Nehru died. Now, although the 17th Amendment was challenged as being unconstitutional, the challenge was rejected by the Supreme Court in a case called Sajjan Singh and Rajasthan. But a further challenge was brought, this time a more comprehensive one, which included a plea to reconsider the Sajjan Singh verdict. And that was in the monumental case of Golaknath. This case deserves slightly more elaborate treatment. It arose out of a law passed in Punjab, under which 418 out of 500 acres of land owned by a family, that is the Golaknath family, was sought to be snatched away and distributed to their tenants. The Golaknath family were, incidentally, originally from Bengal, and they had converted from Hinduism to Christianity. They had settled in Jalandhar, running the Scottish American Presbyterian mission there. Their case was heard by an 11-judge bench, which ruled quite dramatically and by a 6-5 majority that Parliament had no right to amend any of the fundamental rights, and that all previous amendments were therefore invalid. The judges in the majority were of the view that there were certain implied limitations on Parliament's power, and that anything that would result in the destruction of the Constitution should be prohibited. This was a precursor to what became the basic structure doctrine. Now, this judgment set the cat amongst the pigeons and proved particularly provocative to Indira Gandhi, who had by then become Prime Minister, and her supporters, who had been engaging in socialist rhetoric with increasing vigor. An interesting twist to this case was that the Supreme Court, realizing the practical difficulties that would be caused by the judgment, also ruled that the judgment would only be effective for the future, using a technique called prospective overruling. An interesting aftermath of the case was that within weeks of it being concluded, the Chief Justice Subbarao, who was in the majority, announced his intention to resign and to become the opposition party's consensus candidate for the presidency of India in the elections which were to be held shortly thereafter. He lost to Zakir Hussain. Another sidelight of this case was that Ashok Sen, who was the law minister who had steered the 17th Amendment through Parliament, was one of the lawyers on the side of those who challenged that very amendment. The Golaknath case caused a lot of turmoil, but those who valued fundamental rights and the Constitution as originally enacted considered it the high watermark of judicial farsightedness, courage, etc. It's worth remembering that the judgment came at a time when there was an extended state of emergency in force. Now, this emergency had been declared during the Indochina War of 1962, but had not been revoked, something which many people considered very troubling. By coincidence, around the time of the judgment, the Congress party began developing internal fissures, which were made worse by the fact that it had lost heavily in the general election that had just taken place. This led Indira Gandhi to fulminate against what she called reactionary forces within her party and outside, and to contemplate more drastic measures. In July 1969, her government nationalized the country's leading banks. In May 1970, the next year, it abolished the privileges of the country's erstwhile rulers, both highly controversial measures which caused ripples in political circles, but which yielded rich electoral dividends because the Congress, despite an internal split, was soon returned to power with a massive majority under Mrs. Gandhi's leadership. These measures also restarted the tussle between the courts and the government. The stage was set for two major battles to be followed by the biggest fight of them all, which came in the form of the Kesavananda Bharati case. The two major battles were firstly the case of R.C. Cooper, in which the nationalization of the banks and the 25th Amendment to the Constitution was successfully challenged. And secondly, there was the case of Mother Rao Scindia, in which the abolition of privy purses and other princely privileges, and also the 26th Amendment, was attacked, again successfully. An attempt had also been made by Mrs. Gandhi to nullify the Golaknath case by passing the 24th Amendment, which ordained that Parliament could alter any part of the Constitution, including fundamental rights. So, that amendment, along with the 25th, the 26th, and the 29th, was comprehensively challenged in the Kesavananda Bharati case. After the longest hearing of any case in the history of the Supreme Court, and this hearing lasted for 69 days, a 13-judge bench of the court delivered in April 1973, a judgment that holds the fort even today. On the one hand, the court removed the fetters that had been placed by the Golaknath case by ruling that Parliament could amend any part of the Constitution, including fundamental rights. But on the other hand, it held that no amendment could abridge or destroy the basic structure of the document. While there was cause for jubilation on the part of those who had brought the case, and this judgment is not without its problems. In my last lecture, I tried to outline the major difficulties that it poses to this day, and those difficulties are not by any means trivial. The Kesavananda Bharati case is notable for many things, and that is why I'm spending a little more time on it than on some of the other cases. For a start, it was and is impossible to arrive at a clear, definitive ratio or conclusion reading the 11 separate opinions delivered in this case, because there was very little coordination or collegiality among the judges who heard the case. The judges were actually at loggerheads with each other, and there was rampant factionalism. 4 of the judges refused to sign a common statement issued at the end of the case. And this bickering is described in vivid detail in a book authored by the late Mr. T.R. Arujuna and published in 2011. The other noteworthy aspect of the Kesavananda Bharati case is that it led to swift punishment for 3 of the judges in the majority. Mrs. Gandhi's government superseded them for the position of Chief Justice, disregarding decades of settled convention. One more judge in the majority, H.R. Khanna, also suffered a similar fate, but a few years later, when he wrote a powerful dissent in the monumental habeas corpus case, which was heard during the emergency of 1975 to 77. There is only one other case that I have time to mention in the long series of cases dealing with the right to property, and that is the Minerva Mills case. This case was heard after the 1975 emergency had ended, and it was a well-planned attempt by Nani Palkhiwala to reverse the effects of the notorious 42nd Amendment that had been passed during the emergency, and which, for reasons that did little credit to the Janata government, that government failed to do. The single biggest achievement of this case, that is the Minerva Mills case, was that the long-running dispute about whether fundamental rights or directive principles had supremacy inter se was finally settled, mercifully in favor of the former. Now, lack of time prevents me from saying more on this subject, except to add that the abandonment of the right to property by everyone concerned, and in the case of the believers for tactical reasons, was, I think, deeply regrettable. I strongly believe that the right to property is a cornerstone of every free society, and India will, I fear, mourn its loss one day. I want to now move on to another important area of the law, namely civil liberties. Here, the Indian courts have had a mixed record. During the 1975 to 77 emergency, it was clear that the high courts did a much better job of protecting civil liberties than the Supreme Court. But to start at the beginning, the first major case that came up for adjudication was the case of A.K. Gopalan and Madras, which was heard within weeks of the Constitution coming into force. Here, the Preventive Detention Act of 1950 was challenged by a communist politician who had been detained under it. He argued that this law violated many provisions of the Constitution, but the court came to the conclusion that as long as the procedural requirements of preventive detention were complied with, namely that there was a law which authorized such detention, then the detention should be upheld. In other words, it was not open to the courts to carry out an inquiry into the substantive fairness or justness of the law, what is sometimes called substantive due process. But the court did hold that a section of the Act which extraordinarily prevented the court from knowing about the grounds for detention or about any representations that had been made against the detention was invalid. In short, the court took a very narrow view of the scrutiny that is permitted in preventive detention cases. Lack of time compels me to fast forward to the habeas corpus case. This was arguably the most shameful judgment delivered by the Supreme Court, not so much for the disappointing nature of the result alone. There are many cases where that has happened, but for the sheer spinelessness and hypocrisy of the judges, especially two of them who in subsequent years desperately tried to present themselves as champions of human rights and the rule of law. The background to this case was chilling. A large number of people had been rounded up and jailed across the country without charge or trial, mainly under what used to be called MISA, the Maintenance of Internal Security Act, as soon as the emergency of 1975 had been proclaimed. Some of these detainees had been ill-treated, even tortured. The government had suspended the constitutional provisions relating to the right to life, among others, and also the right to seek relief from the courts. It's worth noting that habeas corpus is an ancient remedy which allows higher courts to inquire into cases of alleged illegal imprisonment and to order that the detained person is brought before them so that they can, if no reasonable cause is shown for the detention, release the person. It is one of the most effective weapons against oppressive behavior. Now, despite the high-handedness of the emergency regime, some 9 high courts in India had allowed petitions from emergency detainees. But the government appealed those decisions, and the case was heard by a 5-judge bench, which held that as long as the presidential order suspending rights was in force, the detainee was without any remedy. In the course of the hearing, when one of the judges asked the government's lawyer if this meant that during the emergency, a detainee's life was taken away, say out of personal spite by a policeman, his relatives could not seek judicial redress, the lawyer answered in the affirmative. 2 of the judges in that case, Bhagwati and Chandrachud, went out of their way to ingratiate themselves with the government and made observations which were as uncalled for as they were insulting to the detainees. History will hopefully show them in a darker light than many contemporary commentators have done. On personal liberty, one other case deserves mention, that of Maneka Gandhi, decided in 1978. Here the issue was whether the government could impound a citizen's passport without giving him, or in this case her, the reasons for the impoundment. The Supreme Court, in a bombastic judgment, which many saw as an attempt by Justice Bhagwati to rehabilitate himself after his despicable behavior during the emergency, the court ruled that the procedure followed by the government in such cases should be reasonable, just, and fair, and not arbitrary. The larger importance of this judgment is that it decisively departed from the approach taken by the court in the Gopalan case in the matter of personal liberty. Unfortunately, this case also started a trend which is highly debatable, namely of holding that all manner of other rights can be deduced from the right to life and personal liberty. Such an approach runs the risk of making that right unmanageable and producing unintended or undesirable consequences. To give an example of this, we can turn briefly to the case of Olga Tellez and the Bombay Municipal Corporation, which was decided in 1986, in which the question of the eviction of those illegally occupying public land was considered. The case arose essentially out of pavement and slum dwellers in Bombay who had been proliferating limitlessly and who were asked during heavy rains to clear the land on which their unauthorized shanties had been built. In a round of litigation in the Bombay High Court, solemn undertakings were given on behalf of the slum dwellers that they would vacate the lands by a certain date. But that did not happen. Instead, they went to the Supreme Court arguing for much more. Among other things, that removing them from the pavements and other lands would result in a deprivation of their livelihood, that the occupation of the pavements had resulted from economic compulsions, which meant that the occupants could not be called trespassers, which they clearly were, and that the right to reside and to settle in any part of India should be given a wider meaning to provide the pavement dwellers at least as much a claim on footpaths as pedestrians. Obviously, many of those arguments would strike decent, law-abiding citizens as astounding. But there is also the humanitarian angle to be considered. The court unfortunately made certain gratuitous observations, all based on a so-called expanded conception of the right to life and personal liberty, which have the unintended effect of, I would say, encouraging wrongdoing. I fear I'm getting close to the end of my time, but I want to draw your attention to one or two more landmark cases. Firstly, in relation to the courts, there are three cases which, taken together, have determined the fate of judicial appointments in India. Following the large-scale harassment of judges during the 1975 emergency, it was felt that there should be some guidelines on the transfer and appointment of judges. In the first of those cases, S.P. Gupta and the Union of India, which was decided in 1982, the Supreme Court ruled that correspondence relating to judicial transfers and appointments should not be kept secret by the government, and that although the government had to consult the Chief Justice of India in relation to appointments, its view would prevail if there was a disagreement. But when the issue came up again in another case, which was the case of the Supreme Court Advocates on Records Association and the Union of India in 1993, the court did an about turn and ruled that the final decision on appointment should rest with the Chief Justice, except that he would now have to take those decisions as part of a collegium of 3 senior judges. In yet another case, which came up in 1998 through a presidential reference, the court hardened its stance and confirmed its, what I would call its empire-building tendencies. In this case, it expanded the composition of the collegium to 5 senior judges. Applying the logic of the second and third judges' cases, the Supreme Court, to the disappointment of many people, vetoed the idea of an independent National Judicial Appointments Commission, NJAC as it was called, in another landmark case of the Supreme Court Advocates on Record Association and Union of India in 2015. This is also a case which deserves to be noted. There is hardly any country in the world where judges alone choose new judges. And this issue, in my view, cries out for reconsideration. Talking of the judiciary, one other case is worthy of note, and that's the case of Rupa Ashok Hura and Ashok Hura, in which the Supreme Court, for the first time in 2002, gratuitously introduced the concept of curative petitions. Briefly, what this means is that it is now possible for a litigant who has lost his case at various levels, probably 3 or 4, including in the Supreme Court, to still try his luck two more times. First by way of a review petition and then by way of a curative petition, both of them in the Supreme Court. If I had more time, I would have dilated on this highly retrograde nature of the so-called innovation. But all I shall say now is that it shows how oblivious the Supreme Court is to the increasing dangers presented by mounting judicial arrears, a problem to which it frequently pays lip service but does little to actually tackle. Lest I give the impression that the work of the Indian Supreme Court has been unrelentingly bad, I want to say that there are some laudable judgments too. I will quickly mention two as examples. First, the case of DC Wadhwa and Bihar, in which the court in 1987 strongly condemned the practice of governments, especially in the states, of repeatedly repromulgating ordinances just to avoid facing the legislatures where they feared defeat for those measures. Unfortunately, that judgment left a loophole that has subsequently been exploited by many governments, including at the center, to continue that unhealthy practice. The second example is the case of R.D. Shetty and the International Airports Authority of India, where the Supreme Court in 1979 laid down salutary principles for the award of contracts by public authorities. These authorities, said the court, cannot act arbitrarily, cannot act like a private individual and deal with any person that it pleases, but that its actions must be in conformity with standards which are not arbitrary, irrational, or irrelevant. There are so many other cases that I could talk about, and I'm acutely conscious that what I've discussed in this lecture barely touches the tip of the iceberg that is case law in India. But I hope I've given you a flavor of some important cases which have determined what I would call the destiny of Indian law. This is a subject on which huge volumes can be written, and the good news is that many volumes have indeed been written. I don't have the time to list all or even give a sampling, but I would warmly recommend two books, both by American scholars, which offer deep insights into how Indian law has developed over the years and how, in particular, the Supreme Court has evolved. The first book is called Working a Democratic Constitution by Granville Austin. And the second book is called Supreme Court of India, The Beginnings by George Gadbois, who has also incidentally written another illuminating book called Judges of the Supreme Court of India. For my part, I shall be talking more about landmark cases because I intend in future sessions to deal with particular areas of law, for example, defamation, contempt of court, individual privacy, copyright, etc. And I can assure you that there are some absolutely fascinating cases in those areas. But for the present, I shall stop here and thank you again for listening to me.
Well, thank you very much. Let me say, as you pointed out, it's an enormous subject, and I think we need to demystify law for the ordinary people. People ask me, you without a law degree, how can you go and practice like this? Well, first of all, I have never practiced for money. I've never taken 1 rupee in any of the cases I have pleaded, argued. Let me tell people that it's not necessary that you must have a law degree before you can go and practice. I tell lawyers, if the petitioner or the plaintiff was not there, you would have no business at all. Because unless somebody goes and files a case, what will the lawyers do in court? Lawyers have to represent their people. Now, when they charge them this exorbitant amount, not all cases, but many cases, then people get impoverished. By the time they get their right, if at all, they have lost a hell of a lot of money. People just decide not to do it. I would say that the younger generation and particularly young girls and boys, they should now develop a psychology that I'll go and argue my own case. I can even argue anybody else's case. Section 32 of the Advocates Act says that any person, if the petitioner or the person who's filed the petition, if he says in an affidavit, I want this person to argue for me and no one else, I don't trust anybody else, then if the court will just satisfy itself that you know the law, and then you will be conferred the right as an advocate to argue. And I've done that once or twice. Now, so let me say to people, why you should learn the law? So they can defend yourself. And you don't need lawyers, provided you have studied the law. There's no need for you to go to university and sit down, do exams, get a degree, and then get registered in the bar council, get a certificate, and then go and start arguing. You can do it without a degree, and all you have to do is just learn the law. And you don't have to learn the whole law. Supposing you are a person who is harassed by defamation laws, then you just learn about the defamation laws. Now, when I first began, one of my most celebrated cases was the Ram Setu case. So I went to the court. All the petitioners before me, including all the Shankaracharyas, the Dharmacharyas, the Khadas, everybody, a big fat petition was filed that Ram Setu is going to be ruptured by the Setu Samudram project. Surprisingly, a project that was adopted in Parliament or informed Parliament by Atal Bihari Vajpayee's government at the pressure of their ally, the DMK. And the rupturing of the Ram Setu, the question became agitated. A large number of our religious leaders, RSS, Vishnu Parishad, all of them signed. The RSS chief, Sudarshan, signed. VHS chief, he became Ashok Singhal, he became a petitioner, and they went to Supreme Court, and Supreme Court dismissed it. They said, we don't look at these things, this is a policy matter, and we don't want any religion to come into it. We are a secular country. Now, so a date was fixed for blowing up the Ram Setu with the RDX by the succeeding UPA government. And there was only 1 week left. And both the RSS chief, Sudarshan, and Ashok Singhal came to me, and because I had been doing other cases earlier dealing with defamation law and defeating Ram Jethmalani, defeating so many people who were feared whenever they threatened a defamation suit. So they said that, you can do it. So I said, but you have already gone and got it dismissed. Now I can't go on the same matter. That the court will find me. They'll probably send me to jail on contempt of court. They said, no, but we can't live with the memory that in our lifetime, Ram Setu was exploded by the RDX. So finally I agreed, because two very, very senior people whom I respected so much, the RSS chief and VHS chief, I went to court, and the court said, why have you come here when the whole matter has been dismissed? I said, the previous people came because they were arguing on religious principle. I am arguing on material economic principles. They said, what economic principles? That's policy. We don't interfere in policy, you know that. Balco judgment, you remember the Balco judgment? Yes, the Balco judgment of 1999, I think, or 98. They said that under the public interest litigation, no policy matters can be considered. So I was prepared for that. I said, well, let me say that you will have to agree that if, and I took out one or two judgments you just now which you referred, if it is arbitrary, if it is unreasonable, if it is biased, then I can challenge even policy issues because public exchequer's money is involved. So they said, tell us how building a building a Sadhu Samudram ship channel project, even if it is going to disrupt, rupture Ram Setu, how will you argue that this is unreasonable, arbitrary, and full of and biased, or subject to biased decision? So I said, first of all, the object of the Setu Samudram project is to enable ships to go through the Park Strait, that is Gulf of Mannar and then Park Strait, instead of going around Sri Lanka, which they are presently doing, which takes 3 times the the number of days as going through this. So in order to reduce costs of transportation and so on, we think for development is very necessary for that. I said, agreed. The objective is that ships coming from say Africa, Europe, coming into Kanyakumari, going to and then unable to go through the ocean between Sri Lanka and India, has to go around and then go to Chennai. But if the ships came and downloaded the freight and the passengers into Tikorin, and then by a railway line they went to Chennai, and then on to Visakhapatnam, and then on to Calcutta, the cost of that is 1/5 the cost of building a tunnel underwater on the surface of the ocean and below the water. That is more costly. Maintenance is more costly. All this I proved. So I said it is unreasonable that you should spend public money for an objective, which is that your goods should not go around Sri Lanka, but go by the shortest route. And the shortest route is by railway, and it is also cheaper. So on that basis, the court, decide to hear it, and I won the case. I didn't win the case on religious grounds. The only thing religious was that court said to me, why is it that you want to save this Ram Setu? What is there? Who will go to the middle of the ocean to worship it? So I said, Lordship, every morning I worship Surya, but I don't go there and come back. So the same way I can worship from the shores. And I said, your name is Ravindran. You should at least be sympathetic to this, having the name Ravi in it. So the court laughed and I won the case. So I'm saying that this point that you earlier mentioned about arbitrariness, about unreasonableness, and about bias, if you can show any policy can be struck down. That is one. Second thing, I got many others, but I will do it later on. I have, changed the course of electioneering, the election polling system, by going and using the same principles to bring in EVMs with VVPAT, that is an additional television set. So this is the famous case of 2014, 2013, when Sadasivam was the Chief Justice. And there I proved that the ballot counting method, which now the Americans are having great problem in their presidential election, will be completely removed if you can do it electronically. There was a allegation that electronic machines can be hacked. So for that, you have a fail-safe position, a TV camera, and that TV camera will take when you fill out the ballot and then put it into the computer that is there, which has all these symbols and names of candidates, and you press that, a camera also clicks it, and so that comes out as a piece of paper which falls into a box, which is then, after the elections or the polling is over, you seal it and keep it. And if somebody makes an allegation of rigging the electronic machine, then you can open that box and do the counting. So the VVPAT was an introduction I brought in. It was heavily resisted by the government. That time it was the UPA government, and the Election Commission came with all a battery of lawyers and so on. And ultimately, I won on the same thing, that bias is caused if the votes are not accurately calculated, so on. So, as you, as a individual citizen without a law degree, can argue cases. You can argue cases for other people also, if you can get under Section 32 of the Advocates Act to convince the judges that you can argue. And judges today, you see, in every other PIL where somebody comes to represent himself or some on agreements of general magnitude, the court doesn't entertain them unless you can prove you know the law, and the registrar gives an examination. In the National Herald case, Sonia Gandhi objected to my arguing the case, saying that I'm not a trained lawyer, I'm not a registered lawyer, the Bar Council doesn't have my name, and so I shouldn't be allowed to argue. And you'll be surprised, after consulting the Chief Justice, the registrar passed an order that Dr. Swamy has now established himself to be far better than the senior most of the lawyers of the Supreme Court, and therefore he does not require produce any evidence that he is not capable of arguing a case, and therefore I was allowed. And on that basis today, I walk just like a lawyer into the Supreme Court, argue. People can't believe that I don't have a law degree. And I tell everybody, know the law. That's the new power in the 21st century. And law is very simple. It's all logic and memory. And I'm not belittling your profession, but I'm saying that don't be at the mercy of lawyers. I'll conclude this by saying there was an old joke which was told to me by a very famous lawyer who said that there was once a football match going on in hell. And so somebody kicked the ball very hard, and it went and hit the wall which divides heaven from hell. And the wall collapsed. So the people of heaven came and said, hey, you guys have broken this wall. You must rebuild it. So the hell people said, why we should build it? You're afraid of our coming there. We are not afraid of your coming here. So you, for your own protection, you build it. So they went to Brahma's court. And you would be surprised, the hell people selected amongst themselves the best lawyers they could find and brought a big battery. But the heaven people couldn't find a single lawyer in heaven. So that is the joke that goes about lawyers and how they fleece money and so on. So I think it's an exciting field, law. I would especially tell women, girls, because they are the ones who need most protection of the law today, that you either take a law course or you learn law by yourself, and that's easy to do so. You don't have to go through books, but there are enough judgments which will teach you how to place the arguments, what are the key issues, and so on. And I'd like to see more and more people becoming independent of lawyers, so that the demand supply situation changes, and the lawyers will also charge lower fees than they are charging today. So we'll meet again, and maybe.
Quick question, Dr. Subramanian. There was one question. This is regarding the Kesavananda Bharati case. How big was the judge bench?
13 judges.
13.
What was the ratio?
It is very
Carry it on
difficult.
the front foot. Yeah, go. You tell me.
Okay.
You say.
Okay, in this particular case, it is problematic because really what happened was the bench split 6-6. So it was a tie, except that the tie was broken for practical purposes, not for theoretical legal purposes, but was broken by the judgment of Justice Khanna. So what Khanna did was he came in and he propounded a series of principles which in the end prevailed, particularly about the basic structure and all that. So it is a very problematic decision, and I think anybody who says I can give you a very good explanation of the ratio, the conclusions of the Kesavananda Bharati case would be lying, because it is not possible to get it. It's very, very difficult. And of course, there was also a lot of infighting between the judges. And remember, the Kesavananda Bharati case had another problem. They were coming up against a very strict deadline when Justice Sikri, the Chief Justice, was retiring. So if they did not complete their work by the 25th of April of 1973, then they would have to rehear the case all over again. So one of the most problematic cases in that sense. Sorry, Swamy, you were going to say something.
Yeah, I'm going to say, I'd like you to look at, perhaps next time tell us, there's a famous case of Bommai.
Yes, S.R. Bommai, yeah.
Yeah, 1993. What happened is I was the president of the Janata Party, and my state president in Karnataka was Devagowda at that time. So Devagowda said to me that I would like to bring down the Bommai government, and I can do it by just kidnapping a few MLAs. So I said, if you're going to do all that, don't tell me about it, because I don't want to be part of this thing. But you are state president. Whatever you do, you face the law. So he managed to do that, and so the government fell. So Bommai went to court, and in that the basic structure has been re-emphasized by, I think, all 9 judges unanimously. And I think the basic structure, reading the ratio of the Kesavananda Bharati case and the Bommai case, is now come to stay. The basic structure case.
So, fundamental rights are part of the basic structure. Fundamental rights part of the basic structure. Was that because of the Kesavananda Bharati case or Bommai?
No, Kesavananda Bharati case has made the concept, and I think the ratio is sufficient in majority. I think with the one going this way or that way would have changed it. So I don't think there's any illegality or impropriety to refer to the basic structure idea to the Kesavananda Bharati case. It was introduced then, but it's been fortified.
Okay.
By what is basic structure? What are the elements of basic structure? Can India become a theocratic state? They say no. Secularism is part of basic structure.
Okay.
And like that, they list the components of basic structure.
Yeah. Okay.
Can I specifically address Ramesh's point? The short answer to that question is no. Are fundamental rights part of the basic structure? The short answer is no. But there is a longer answer, and the longer answer is it depends on what aspect of fundamental rights you're looking at. So, for example, if you were to talk about judicial independence, or you can deduce certain concepts from fundamental rights, like the rule of law. Now, the rule of law is a part of the basic structure. But if the Kesavananda Bharati case had decided that fundamental rights were themselves, as a whole, part of the basic structure, then that would be exactly the same as what Golaknath said. So they had to actually say we are overruling Golaknath and saying that not all fundamental rights form the basic structure. But we will look at it on a case-to-case basis. And as Swamy said, there is a Bommai case. There are so many other cases that have come up subsequently in which the basic structure doctrine has not only been considered but also affirmed. And again, I'm quite happy in future episodes to at least list those cases if I don't have the time to go into the details of those cases. Sorry, Ramesh, there's something else you wanted to say?
One last thing, because you mentioned in the earlier case of Golaknath that they said the government has no right to modify the constitution. And I guess
No.
they kind
No, not constitution,
Right to
only
property.
fundamental rights.
fundamental rights. Okay.
Yeah.
Fundamental right to property.
No, all fundamental rights.
I have a
No,
question.
because in the concept of property rights, the case came.
Case was about property rights, but the
Yes.
proposition in the case covered all fundamental rights,
Yes.
which were in Chapter 3.
Yeah, that's right.
No, I
And
have
that
a
was-
question for Venkat.
Yeah.
Yes.
I have a question for Venkat. Venkat, what was the outcome of the Kesavananda Bharati case? Means what exactly happened? You say the 6 and +1 and all that. We want to know what happened. He came in
Okay.
challenge from Kerala High Court, I believe.
Yeah.
Unfortunately, Kesavananda Bharati is no more. He just passed away in our COVID period recently at the age of 80. But
Yeah.
please tell us something about that case. He came in appeal perhaps, and Palkiwala perhaps appeared also in the matter.
Palkiwala was the lead counsel. Okay, now the question you're asking is slightly difficult to answer, because what happens in these big cases is that the Supreme Court deals with broad principles. It doesn't go into whether His Holiness Kesavananda Bharati's 23 acres had to be protected or not. That is not how they do it. So what happens is they lay down these broad principles. The case is then decided at a lower level. Now, what happened at the lower level, I'm not personally familiar with, although I have read in many places that Kesavananda Bharati himself did not actually get what he had been hoping for as a result of the case, although he was in broad terms very happy because a very important principle had been laid. And don't forget one other very important thing. Sometimes you are misled into thinking that the case is all about Kesavananda Bharati. Actually, it is not, because Kesavananda Bharati is the lead name. Now, actually, this is a combination of many cases that come up, and there are many interveners, incidentally. I'll tell you what the trick of the lawyers is. They always try to give the name, or give the case a name that is very innocuous, very attractive. So you bring a saint's name, a godman's name. Actually, the people fighting the case are usually moneyed capitalists. I have nothing against them. As it happens, I very strongly support capitalists. But
No, the first person to file the case,
yes,
the SLP, was Kesavananda Bharati.
well,
So that's why
actually, it's even more complicated than that. Again, this is I'm revealing the tricks of the trade. What actually happens is lawyers go out of their way to go and locate somebody who can be used. They'll go and say,
I don't know whether he was procured that way.
Yeah.
His name was filed. His petition was filed first, because I have this problem. I come up with like 2G. I went on the 2G thing, and then everybody went in because they also want and Ram Mandir. People just come in because they want. There's like leeches, They want to get the benefit of the prominence of having appeared in this case.
Yeah, even
And then I will show that,
Even the Jayalalitha case.
Yeah, that's right. The DMK guys got into it.
we call them parasites.
Their name,
We call them parasites.
Parasites,
So,
yes.
What happens is that, well, in the case of Kesavananda Bharati specifically, they actually were lucky because Kesavananda Bharati had already filed a case in the Kerala High Court. So they had a ready petitioner. They didn't have to go too far looking for a person like that. But in certain other cases, they have actually done that. So lawyers go out of the way.
I agree.
Lawyers. Yeah.
In fact, I think the original case was Kesavananda Bharati was a head of a mutt or a trust in Kasaragod, and the government, under some of the land reform thing, was trying to take over that land. I think it all originated from that, if I'm not mistaken.
You're absolutely right. It was called the Ednir Trust. And it was near Kasaragod. And Kesavananda Bharati was the the chief abbot of that particular trust. So in this case, yes, it was a fortuitous coincidence. Sorry, Swami.
Yeah, see, but we now have a new section, the new article in the Constitution called 100A, which says you can, and 31A. In fact, that's the more important one.
Dr. Swamy,
31A,
300A.
31, no, not 300. 31A bracket 1 bracket D. That I think the number to distinguish it from the earlier 31, and that says you can take over property, but it has to be for a limited period. So that's essentially what I'm using for the liberation of temples. I'm saying, yes, if the temple is mismanaging its finances, the government can take it over, but it has to be for a temporary period. And that's how this Uttarakhand case, they are taking it over for perpetuity. And somehow the judge didn't understand in the High Court level. I don't know what was his problem. He retired the very next day after giving the order. So I couldn't even go back to him and ask for a review. And so I'm coming to the Supreme Court. Even in the Sabanayakar Nataraj temple, I lost in the High Court. And then I came to Supreme Court and won the case. And that has laid down the law now.
Venkat, one other comment that just came up. What about the Vaman Rao case? Even they say that the basic structure was distilled or diluted by the SC.
Well, it was. I would have needed more time to discuss that
we'll
case.
do that tomorrow, next week. We'll take it up. This seems to be a very interesting subject. We'll carry it on to the next week.
It is undoubtedly a relevant case for basic structure. So I had it in mind, and in the end, I decided I didn't have the time. So I'll certainly, okay.
Okay, we will be ending this program. Very interesting discussion with these remarks by Dr. Swamy and Venkat. But one remark I would definitely like to make, although Dr. Swamy is not a lawyer, but he has numerous reported judgments on his name. Maybe in one day, in a future episode, we may discuss some of these reported judgments, and perhaps Dr. Venkat Iyer may tell us what is the meaning of a reported judgment, because our viewers would also like to know. But to Dr. Swamy's credit, unlike many of the senior counsels who are parading as senior lawyers, some of them being part of the government, hardly having any reported cases to them. But Dr. Swamy has the, I would say, the privilege of having many of these reported cases, or landmark cases. Dr. Swamy versus Manmohan Singh, Dr. Swamy versus the state of Tamil Nadu regarding the Nataraj temple, and in the 2G matters and other matters. So with this, we end our program, and we'll be back for our legal words of wisdom next Saturday at 8 p.m. And tomorrow we will be having our regular words of wisdom, Gyan Ganga. And tomorrow we will be having a very detailed discussion on the latest happenings in the international relations, current relations in reference to the US presidential elections, and also regarding Russia. So tomorrow we'll be there at 8 p.m. On our words of wisdom. I thank Dr. Venkat Iyer and Dr. Subramanian Swamy for having discussed in today's the 6th episode of Legal Words of Wisdom. We are very likely, we are making this as just an informal announcement, very likely to have economic Gyan Ganga or economic words of wisdom, perhaps from a future date or after our legal words of wisdom conclude. And we are also thinking of having Sanskrit, online Sanskrit classes for some of our registered members. There'll be a different concept, not like a public show or a public talk, but for the registered member, with Sanskrit Bharati, we are trying to do a tie-up, perhaps from Gita Jayanti, which is usually in December. We may have this type of program. As Virat Hindustan Sangam says, educate and empower. So these are some of the part of our mission or vision of Virat Hindustan Sangam. So with this, we end our today's program. Hope to see you next week for our legal program and tomorrow at 8 p.m. for our regular program. Thank you. Dhanyavadam and Jai Hind.
Thank you.